Hello, Algorators. Court is back in session, and I'm Al Reynolds, and this is the Court of Public Opinion. I'll be serving as your judge, and you, the viewer, will be the jury. The Court of Public Opinion is a place where you, the people's voice, can and will be heard. Be sure to hit that like button, and if you're not subscribed, be sure to hit that subscribe button. And if you are subscribed, be sure to share with a friend. And don't forget, we love the engagement. So keep it coming with the comments. Put those comments in the chat. All right, let me introduce for Ladies Night because today is Ladies Night. Friday is Ladies Night. And let me introduce my two legal beagles. First up, we have corporate attorney Kyra Coffee. Get those coffee emojis ready, everybody. And joining her tonight will be our entertainment attorney, Jordan Williams. Welcome back, Jordan.
Hello,
and what did we decide? What yours was blue hearts?
Yes, the blue hearts.
All right, get those blue heart emojis together. So don't forget to Ladies Night. And I am deeming court is now in session. First up, Love and Marriage Huntsville. Oh my goodness. Who knew? Who knew? Martell Holt has earned his keep on that show. We know that. The way he stays in the blogs. But we are out of the blogs and we are now in the court of public opinion. And let me tell you, Melody is saying Martell is violating his custody agreement. And he and his new side chick, yeah, you heard me right, his side chick is bullying the kids. All right, entertainment attorney, lawyer, I need some insight on this, Miss Counselor Williams. What is going on here? And what is Melanie actually saying? Is she saying that no longer can they have joint custody, but that she only wants sole custody because of the bullying? Can you share with me, Attorney Williams, what we got right here?
This is such a crazy child custody case. So as we all know, if you watch Love and Marriage Huntsville, Melody and Martell Holt divorced a few years ago, but they have since been in court battling over child custody. So they had joint custody of the kids, 50-50 split, but Martell is actually who initiated seeking full custody, which obviously caused Melody to retaliate and say, no, actually, if that's what we're doing, give me full custody. So in the latest filings, she's actually alleging that not only has Martell not gone to court-ordered therapy with their son, but he has continued to physically harm the kids, bully them, choking them, threatening them, and talking negatively about her around the children. She's also alleging that Martell's side chick's daughter, who lives with the side chick, but is around the children, has been bullying the kids as well. So this is a very messy family situation. It looks like Martell has absolutely no control over what's going on because those claims that Melody has listed, they are insane. And hopefully Martell is not actually putting his hands on the kids because they had an agreement that neither parent would do corporal punishment with the kids. So Melody is also alleging that Martell has violated that agreement. So if all of this is true, Martell has a whole host of violations, and I know the judge will not be happy.
So, Attorney Coffey, is it safe to say that the court has the right or people have the right to interpret, since he can't practice corporate punishment, that he has to use other measures in which to discipline his child, which could be examined maybe or interpreted as bullying?
No, if he doesn't have the aptitude to properly parent his kids, that's a problem, which I do believe that the order did say something about him going to like parenting classes or something to that degree. And what was also interesting was that in addition to just saying no corporal punishment, they actually defined and gave examples of what it was. So it really just lends itself to he doesn't really have the proper skills or capacity to properly parent his kids. There are several other ways to discipline a child without putting your hands on them. And it's a shame if he doesn't know any of them without resorting to bullying or allowing someone else to bully his children as well.
All right, now hold on, counselor. Now we're talking about bullying is also being accused of the daughter of the side chick. Now the daughter of the side chick clearly is not putting her hands on the child. There's
No.
nowhere in the court documents is the daughter of the side chick's hands been put on the child. It's the language that's being used towards the child. So my initial question and my remaining question is, can he be using other tactics besides corporal punishment, which is being interpreted as bullying?
No. It does not seem like from the petition that was filed that they are alleging non-bullying acts as bullying. It seems like what they are asserting is in fact inappropriate conduct towards the child and trying to discipline them. So I do not believe that there were any acts that were classified as bullying that should not have been. So I do believe that he is not properly parenting his children, that he is to some degree bullying them and allowing others to bully them as well.
Okay, Attorney Williams, this is what I need clarity on in this particular case, because I feel like, and I have been a part of a family structure where my parents, my dad's in the military, and my mother was a teacher. They had rules, and my parents were very clear that if you broke the rules, that there was accountability. And the way that they talked to me, a lot of people, the way they talked to all my brothers and sisters, a lot of people would say that it was very aggressive, and that you should just let kids be kids, and you shouldn't be holding kids at such accountable levels, because in fact they felt that my parents were like being too forceful. Resume. Okay, so this is my question. So my dad was in the military and my mother was a teacher, and we grew up in a very kind of discipline and accountability household. And a lot of people felt that my parents were actually too harsh on us, that my parents actually would, in some of my colleagues, especially, the other white families in the communities that we grew up around, thought that my parents were a tad bit of a bully. So I'm asking this question, Attorney Williams, could this be the case? Could he be interpreting, because he's not allowed to touch the kids, right? Because of the corporal whatever. Could it be interpreted the way that he's disciplining his kids? Could it be interpreted as bullying? But in fact, maybe it's not.
Well, he's being accused of bullying the kids, but he is also being accused of physically harming the children. So if you look in the court filings, they kind of go a little bit more specifically into what Melody is accusing Martell of. So some of those things even include showing the children videos of Melody on dates with other men and making certain negative comments about Melody. So it doesn't even seem like it's, trying to toughen them up or instill some discipline into them. It really seems like pettiness. There's also, if you all have been kind of on the up and up with what's going on the show, Martell was recently arrested for threatening to release a S tape featuring Melody, right? And in those court documents, there actually are texts from Martell to Melody saying, if you don't leave me alone, I'm going to release this, with a screenshot from the tape. So it seems like these two have a lot of legal drama between them. But from reading the filings in the custody case, it seems like Martell is unfortunately using the children as a way to be petty towards Melody, again, if what's in Melody's filings are found to be true.
Gotcha. Okay, Attorney Coffey. Mm-hmm. Let me bring it back to you for a minute, because I don't know how engaged you are in reality television, but right here in the court of public opinion, a lot of those cases end up in this court. And what I'm hearing from my ears as the judge is I hear a storyline. I hear that these two, because they have divorced, and technically, how do you keep two people on a show that is called Love and Marriage, but they're not married? So in order to stay on the show, it just seems like they keep drumming up more and more and more and more and more mess to make sure that contract gets re-signed to bring them back. Could this be a factor in this case, Attorney Coffey?
That is an interesting point. And I dip and dabble in the show. And so I do feel like the tension between them is a big part of their storyline. However, it is very aggressive to go to the measures of legal implications, legal proceedings, especially involving your children. So if they are using this ploy to keep a storyline going, That's kind of disgusting. Like I say, involving your children, allegations against your children. Now, if it's just between the two of them, oh, I'm going to release a tape and this, that, and the other, okay, whatever. But again, to bring the children into it and his image as a father, I feel like that's very detrimental to his reputation, his character. But maybe he doesn't care. I don't know. If they're using it as a storyline, that's very pathetic in my personal opinion.
I think in the
And
court
to
of,
just
right, go ahead.
to just add on to that, I agree it's disgusting. But also, when you again look at what Melody filed, she's saying that Martell is not even going to court ordered therapy with his children. That has nothing to do with TV. Martell, why you can't go to therapy with your son? What's the problem? Again, hopefully that's not the storyline here. I think that, from what she's alleging in these filings, it just seems like Martell's being trifling and just doing what he wants to do, despite what the court has ordered him to do. So
order in the court. Now, y'all know I'm not gonna let you two ladies beat up on a man just because y'all are trying to see this one way now. Now, if he's putting his hands on the kid, the court will not have it. But we're not gonna have our two attorneys and my legal beagles beating up on the men every time the man and the woman gets in a situation. All right. With that being said, let's keep it going. Well, court of public opinion. Did you like the show Mixed-ish, which was created by Kenya Barris and Traci Ellis Ross, which appears on ABC? Well, they've landed here in the court of public opinion because a writer is suing because she's saying they stole the idea from her because she had already told Traci Ellis Ross about it. Entertainment attorney, because this is entertainment. This is ABC, and we know our entertainment attorney works at a huge company that creates content. An entertainment attorney, Jordan Williams. What are your thoughts on this?
This story is a little crazy to me. So before Mixed-ish ever was actually a thing, this particular writer had a show called Mixed that she actually registered with the Writers Guild. So she's saying that she actually started having conversations with a particular production company, and her idea kind of shifted hands and eventually found its way to Traci Ellis Ross. Obviously, Traci Ellis Ross has worked with Kenya Barris on the show Mixed-ish, which, by the way, I've seen and I love.
Blackish
with the spinoff of Mixed-ish.
That's right.
And what's interesting about this is she's saying they stole her idea because of the flashbacks. So if you've seen Mixed-ish, there are a lot of flashbacks in both Mixes and Blackish, actually. So she's saying her show was also about growing up as a biracial girl and had a lot of flashbacks to her childhood. Well, initially, Kenya Barris and ABC were immediately dismissed from the lawsuit. However, Traci Ellis Ross was still being held on the hook. She actually just got a chance to dismiss herself from the case through what we call anti-SLAPP, and I'll explain what that means. Because the court ultimately found that, hey, you may have told Traci Ellis Ross your ideas, but there was never a contract where she was required to pay you for those ideas. And she never promised to make you a part of the show. Really, you just blabbed off at the mouth. And unfortunately, you two had similar ideas. What also was in Traci Ellis Ross's favor was that the concept of Mixed-ish had already been happening before she had the conversation with this writer. So I think the court was able to see that, hey, Mixed-ish was not based on your idea. Anything that you said to Traci Ellis Ross, for all we know, they already had going on. Now, let me go back to the point about anti-SLAPP.
Yes.
When someone, particularly in states like California, Texas, New York, have these anti-SLAPP laws that pretty much protect you from frivolous lawsuits. So, for example, if we're here reporting on someone and they just happen to not like what we say, despite the fact that we are telling the truth, they may sue us just to bully us and try to discourage us from reporting on them. Well, under anti-SLAPP, you can actually countersue them and tell the court, hey, this person is only suing me because they're trying to shut me up. The court will not allow that to happen. Under our First Amendment rights, we can say things, they must be true, even if they are negative, even if they are embarrassing. So Traci basically said, hey, you are just trying to discourage us from moving forward with the show. You're trying to get money out of me. There's no reason why I would owe you anything. You just told me your idea. I already had the same idea, so I didn't even need anything from you. And Traci Ellis Ross was able to get dismissed from the lawsuit as well.
All right, now let's go to you, Attorney Coffee, because there's some things here that I don't like and there's some things that I do like. If someone is pitching an idea to you, number one, and I'm just a judge thinking outside of the box. If someone is pitching you an idea that you've already had, why are you listening to it? Let's be very clear. Now, the fact that she's got good lawyers that have learned how to massage her out of the law system and they both been dismissed from it doesn't mean that they didn't do something wrong. We all know that. That's how it works in law. Legally, you can find a legality. A person who has done you wrong can not be held accountable. Now, the question to you, Attorney Coffee, is there are tons of people that watch this show that follow me, will be following the two of you ladies. I get all the time people pitching me their show ideas or segment ideas or other projects that they think I should be a part of. Attorney Coffee, can you please share with us and our viewers and our jury members what they should do in order to protect all ideas so that they don't find themselves on the wrong side of the law when they actually were right?
Absolutely. So one thing that is very important, and I always recommend to do first and foremost, is to have an NDA agreement, which is a non-disclosure agreement with any parties that you are having a conversation with. That includes protected information. So if you have an idea that is possibly registered, which is amazing, or not registered, it doesn't matter regardless. You want to have a non-disclosure agreement. And what that does is that protects any ideas that are expressed. So if you express something that is your intellectual property, it retains and stays owned by the original owner, and no one can then take those ideas and flourish with them thereafter. You can also potentially sometimes put in a non-compete so that they cannot then take your idea and become your competitor. But you, if nothing else, baseline wants to have an NDA agreement and specify why you're having this conversation, what information as best as possible will be revealed, and that it does not guarantee a partnership, and that you are retaining ownership of whatever it is that you're relaying. And then if possible, definitely go, if you have a script that's written, go and get it copyright protected, so that then adds another layer of protection if you do have to sue later. And another thing that I do like to do sometimes after conversations are had, sometimes I will send an email to vaguely recap what was disclosed, so that if later somebody tries to say, oh, we didn't talk about that, I didn't know X, Y, and Z, well, there was an email stamped at that time in place of whatever that conversation happened that gave enough information to share and, summarize what exactly was said, so that someone cannot later come and say, well, they never told me that.
Absolutely. Thank you, Attorney Coffee. Let's go to you, Attorney Williams, because you actually work at a streaming company that is a network. Is there anything else that you would want to add? I just want to add that you can also know not just email, but text message, voice messages, text messages, and handwritten is admissible as proof as long as you put the date and the time. Those two can be used. Attorney Williams, is there any more advice as a person who is in-house counsel to a network that a person should do when they're sharing their ideas, especially in the television and entertainment game?
Yeah, just like Attorney Coffee said, you 100% should have an NDA. You should have your paperwork together, and you should not be afraid to say, for you to use my idea, I need a credit, I need X amount of money, I need to be producing, or whatever role it is that you want in that show. Take Dolly Parton, for example, right? People love sampling Dolly Parton. She recently had her song done by Beyonce, Jolene. Beyonce recreated the song, but if you look in the credits, Beyonce only credits Dolly Parton, right? She obviously switched up some lyrics and all of that, but that's because Dolly Parton has in all of her contracts that if you sing her songs, no matter what, if you change a lyric or two, you must credit her as the sole writer. So you need to have your business just as buttoned up as Dolly Parton does, because she does not play about those coins.
All right, I like it. And then I also just want to add to this awesome job with this, ladies. I think you did an awesome job with this. That when someone is listening to your ideas, algoriters, being an executive producer, someone says they're giving you a producer credit. Attorneys, please chime in if I'm wrong or correct me if I'm wrong. That is how you get paid. Okay. So because you present an idea up does not mean at that time that you present the idea up that you should be paid. Would any of the attorneys like to chime in on that?
I completely agree. You want that credit. Why do people care so much about IMDb? Because that is your resume. That's how you know you've done the work. This is your actual idea, right? You sometimes see executive producer credits. You will see created by, inspired by, based on credits. Those things matter. I know sometimes as viewers, we just kind of glaze over there. We're really there to watch the show. But when we get to talking about dollars and cents, credits matter. That's why you'll see some entertainers, they are starring in the show. They wrote the show. They directed the show. I'm talking about Tyler Perry, right? His name is all up and through his movies, his shows, but he's getting a check for each one of those credits.
Got it. Excellent job. All right, algoriters, the thumbs up are not matching with the views. Make sure if you like this that you're throwing a thumbs up and hitting that like button. If you haven't subscribed, be sure to hit that subscribe button. If you are subscribed, please share the show with somebody else. And please don't forget, drop down in those comments because the engagement is what we like the most. So if you're liking Attorney Coffee, Attorney Williams, and myself, and you're liking the show so far, don't forget to put those fax emojis in that chat. Don't forget to use those blue hearts. And as always, do not forget to use those coffee mugs for letting us know that you're enjoying the show. All right, let's keep it moving. Charles Schwab. Yep, you heard me, Charles Schwab. Some of us have those accounts. If you don't have them personally, you definitely have them from your employer's defined benefit plans or in your 401k plan. They have landed in the court of public opinion. And guess what? They are not the ones being sued for wrongdoing. In fact, a woman is being sued for using the money that they accidentally deposited into her account to the tune of 1.2 or $4 million. But guess what? Charles Schwab said, no, ma'am, we want our money back. And in fact, because she had purchased a house and a couple of other things, they had her arrested and charged with theft. All right, corporate attorney, we know that this is up your alley. Corporate attorney Coffee, is this really, can they really do this to her?
Yes, they can. And the reason being is that I know that people, rely on the contract theory and things of that sort, the relationship that you have with your bank. But this actually more so falls in the category of theft and criminal law. And that is being that the money was not intended for you. And most times that money, especially a couple $1 million, girl, where you get that from? You know that money is not yours. And so you actually do have an obligation to notify your bank if you do have an excess of money deposited into your account. They will have to launch an investigation, which typically takes 10 days, but can take up to 45 days. But even if they do not and they drag their feet, you still are not allowed to actually spend that money out of that account because it will be criminal charges and criminal responsibilities under theft and conversion of property. So the reason, and I do believe that she was probably arrested in the manner in which she was. I could not find facts about it, but I wonder if they contacted her and her disposition was, one, she was not going to return it. Two, that's y'all problem, that's y'all mistake, not mine. And just no remorse of trying to give the property or give that money back, or even, I don't know how she could do it, but try to replace it. It's not the first time that this has happened. It happened to another couple. I think there's like 150,000, and they spent it, bought houses, bought cars, gave some money away, and the bank came back knocking like, hey, that was a mistake. Where's that money at? And they could not replace it. They were put on probation for several years, as well as community service and things like that. So I think that it was that their response was more so, okay, hey, we're sorry. Okay, we can't return it, but I think no, they were actually able to return like 50,000 of the 150K. But a couple mil, I mean, if I spend that, I don't know where you're gonna get it back.
Exactly. Attorney Williams, let me ask you this, because this is really just underneath my skin. Now, I worked in banking, I was a private banker, and I always had to have my clients sign what was called service and relationship agreements. And in that service and relationship agreements, it does say it. It clearly says that, the banks make mistakes. And if mistakes are made, you are still held responsible to return the money. Now, this is my issue here, Attorney Williams, from the Court of Public Opinion. How did she have time to find a house, view the house, buy the house, close on the house, move into the house, and the bank has never reached out to them and never told them that it was a mistake? Is there a statute of limitation or a time limit in which if the bank does not reach out to you, that the money is yours, in fact? For instance, let me tell you. So, for instance, there are laws, and you two ladies can chime in here. There are laws that if you found money and you return the money, but the money returned is not collected, the person who found the money, in fact, is entitled to the money. Am I wrong?
Yes. I'm sorry, but you are wrong. So when you enter into the agreement with your bank,
not with the bank, I'm just talking about outside of the bank.
You're saying in general?
Yeah, outside of the bank. Now we know with the bank, you got to get the money back.
In general, that is correct.
Right. In general,
that would be correct.
That's right. So the reason why I brought it up, ladies, is because a lot of people feel like finders keepers, losers sweepers. Well, sometimes you're right, but not when there's a contract. And every time you open an account at a bank, you got to read that fine language, everybody. We all don't read it because that fine language will catch you up every time. So my question, though, I want to go back to Attorney Williams on this is there any time limit? So say she kept the money in her account and say she kept it there for a year and the bank never reached out, right? And, she was like, I'm not going to say nothing if they don't say nothing. Is there ever a time limit where it expires that if the bank doesn't reach out to you, you can run down there and go on over there to Caldwell Banking and get you a house?
Well, it depends on the state. Every state has different laws, and I'll just tell you generally how it is here in California. So there is actually a law that you can sue under if you did not previously know certain facts, but you learned them now. You can sue for the newly found facts, even if the incident was old. So the only way I think the bank would not reach out is if they didn't notice. But the minute that they do, they would be able to file a lawsuit in light of the newfound information, especially if they can prove that you knew that it wasn't your money. So I would not take that chance. And I know a lot of us, if we see $1.2 million in our bank account, we think it's a blessing from above.
Absolutely.
I certainly would say, Jesus, I was on your mind today. But don't do it. Don't do it. It's a setup. It's a test. You will probably be sued and you will definitely go to court, go to jail. You just don't want to do that to yourself.
All right. Sounds good.
Just thinking that, to my understanding, you do have an obligation to report that to your bank if you see an excess of money in your account. So it's not just the bank's responsibility to come back and say, hey, we made a mistake. You do actually have an obligation, whether you regularly check your bank account or not, to report that if you do come across it. So
what about their obligation when they mess up in my account, Attorney Coffee? What obligation do they have to reach out to me and tell me that they charged me incorrect, Attorney Coffee? We need some reciprocity in this, Attorney Coffee.
Now, I do hate bank fees, so I'm gonna agree with you on that. But if you're in my house and you find some money in my house, is it your money or mine?
Well, it depends. No, let me.
Right. Exactly.
It depends on you find me or not.
In my house.
All right, y'all gonna get me in trouble in the Court of Public Opinion. Let's leave that one alone. All right, number 4, last one. A substitute teacher, everybody, has found himself here in our courtroom, the Court of Public Opinion, for putting his hands on a student who called him the N-word. All right, Attorney Williams, we know that you have very strong feelings about this. Talk to us, because I'm going to tell you right now, these kids, and you guys know, outside of the court of public opinion, I am an educator. I do a lot of deans. I'm in the classroom. I am in the classroom, and these kids are downright disrespectful. And if you look at this, I look at it as if he was protecting himself, because that little boy was coming after him. And to be honest, I don't find a problem with an adult protecting themselves. However, what does this law say, Attorney Williams?
So he got charged with assault and battery of a student. And that can also be a child in certain states. Certain states define the same charge differently. Two problems that I have with this is, one, in that video, you can see the child putting his arms over his head in efforts to protect himself. So at that point in the fight, there is no threat, right? At that point, you are expected, especially as an adult, to walk away, because the threat of him harming you is gone, right? He's not even fighting back as he's laying on the floor. So I do have an issue with that. The other issue that I have, this substitute teacher actually did not have a criminal record before this incident. This was his first charge. And I just think that he should have had more self-control over himself, obviously not condoning calling anybody any racial slurs. Definitely don't call me one. But at the same time, we have to have a little bit more self-control, because now that charge is...
All right. Hold on, Attorney Williams. Let me tell you something. I don't care what you ain't been in the classroom in a long time. Teachers are getting their legs broken. Teachers are getting slapped. Teachers are getting spit on. Teachers are taking the higher road, and they're getting their arms broken and their eyes blacked. I do have empathy. For the kid, because the kid got his handed to him. But at the same time, Attorney Coffey, help me out here. Now, even not in the land of law, can the teacher protect himself? I feel so bad when I watch all of these stories, and we covered them on my other show, TGIF, of teachers ending up in the hospital, broken legs, fractured bones. At what point do we say, as professionals, our safety comes before our professionalism? Attorney Coffey, help me out here.
I don't know how much up I'm going to be, but I'm going to try. But I do believe that you have the right to protect yourself under any circumstances, and that appropriate force should meet the force that's coming against you. However, my question in this case is, I haven't read anything that said that it was self-defense, and I have not read anything that said that the student physically attacked the teacher first. And so that is where teacher Mr. Smith's problem is going to lie. Mm-hmm. And that, yes, I understand the emotional rage, and I understand, because like my girl Attorney Williams said, don't call me one. It's gonna be a problem. So I understand the emotional rage that draws up, but that does not allow a teacher to put their hands on a student. Just like out in the real world, just because someone called you a racial slur, that one from one adult to another, that would not allow me the right to then put my hands on you, because you did not pose any type of physical threat to me. Now, if you said that in a way and you're walking towards me in an aggressive demeanor, then yes, I can presume that I need to protect myself, because you said these words and your actions lead me to believe that you're going to use some type of physical force. But if the teacher struck the student first physically, that is going to be a problem.
Gotcha. All right, algoritmers, it's that time of the show in the court of public opinion where we make a judgment on the various cases that we covered tonight. All right, with my two legal beagles, Attorney Williams and Attorney Coffey, here we go. In Love and Marriage, Huntsville, did we find Martell Holt guilty or not guilty for violating his custody agreement? Attorney Williams, what are your thoughts?
Guilty. I can just tell that Martell ain't a bit more listen to that judge than anybody else. So,
all right, Attorney Coffey, what do we say? Guilty or not guilty?
He guilty, and it's not. I used to like Martell, but from what I read in that petition, like, that's absolutely absurd. Guilty.
All right, so I'm going to say that he is guilty. We're going to find Martell Holt guilty of charge, because if you're putting your hands on those kids and you're not supposed to be putting your hands on your kids, I don't care how tight your suit is and how many muscles and teeth you show to bulge. This is not allowed in the court of public opinion. Martell is found guilty. All right, ladies, we're moving on to Mixed Dish, where Kenya Barris and Traci Ellis Ross, the writer, said, "You stole my idea." Is Kenya Barris and Traci Ellis Ross, two Hollywood wealthy people, influencers, guilty or not guilty, Attorney Coffee, of stealing this writer's idea?
Not guilty. She may have had some similarities, but nothing substantial enough to say that they stole her show. They're not
Attorney
guilty.
Williams.
They're not guilty, but I want her to go and take a class on content creation, how to protect herself, so she doesn't end up in this position again.
Absolutely. I'm going to say not guilty, but they are definitely suspects in the court of public opinion. We're finding them not guilty, but definitely guilty of being suspect, because y'all have been in this game for a long time. If you knew that you already had that show in your head and was created, then why did you listen to it? But let's keep on moving. Charles Schwab, is this poor lady, is she guilty of stealing the money? Is she a thief like they say she is, when Charles Schwab, a billion-dollar company, is the one that made the mistake? Attorney Coffee, is the lady guilty or not guilty?
My personal opinion is not guilty, but based on the law, she is guilty.
All right, Attorney Williams, what do you say?
I'm going to go with not guilty, because I follow the law of the Lord. And if he put that blessing on her, who is Charles Schwab to take it away?
Absolutely. In the court of public opinion. All right, Attorney Williams, you got me right there. I find that poor lady who got her a good old house and a fancy old car, not guilty. Let that lady have that money. You don't need it. All right, last up, everybody, we have this poor substitute teacher, this educator that is doing the Lord's work. Because I'm going to tell you, to be in the classroom these days, you got to have some faith in somehow. Is this substitute teacher, Attorney Williams, guilty or not guilty for physical assault?
I'm going to say guilty. You have to have more emotional maturity if somebody calls you a name to just walk away. Don't get
All right,
charge.
Attorney Coffee, what are your thoughts? Guilty or not guilty?
I hate to say it, but he's guilty.
All right. In the court of public opinion, Judge Al Reynolds is finding that substitute teacher not guilty. Not guilty, because I'm going to tell you, these kids are bad. These kids are bad as hell in these classrooms, and I've been in them. And I am never going to let a child not only disrespect me by calling me a name like that, but you're never going to run up on me and try to hit me. I'm going to have to put your lights out. And yes, that is here in the court of public opinion. All right, algoritmers, this will conclude today's sessions in the court of public opinion. Don't forget that we read those comments, so make sure you speak your peace of mind and drop down there and let us know how you're doing. If you haven't hit that like button, make sure you hit that like button. If you haven't hit that subscribe button, make sure you hit that subscribe button. And let me tell you, be sure to join us back on Monday at 2 p.m. Pacific and 5 p.m. Eastern for the next Court of Public Opinion. Court is now adjourned.